Alrighty, so this is Deuce We the People News. Alrighty. Without prejudice and without recourse, okay? I'm going to go ahead and stand on the UCC 1-308, all rights reserved, dash 1-207, UCC, by the way. I'm not an attorney and I am not giving legal advice, so if I do say any such thing, it's just my opinion only, people. Alright, I'm doing this video to really because I've shared a couple of times on videos past about jury notification. So this one right here is First Amendment, but it has jury notification involved in it. Okay, so it's a court case, and I thought, well, you know, if you guys want to listen to it, because it has to do with the First Amendment, then it's got jury notification involved in this. Alright, so you're kind of getting a twofer out of this. Alrighty, because to be blunt with you, courts don't want you to know this. They absolutely do not want you to know about jury notification. And the reason why is because, well, you can form your own opinion about stupid laws. Alright. Let's go ahead and proceed forward. I'm going to make a couple of videos of this, you know, because of, you know, the Junkyard News. He does it all at once by kind of breaking it down, just so you can hear part of it and just kind of percolate. Hear another part. Percolate and kind of study what these lawyers' arguments are in the First Amendment, and then the jury notification involved in this and that here and there. Okay? Alright, let's go.
It's the right of the jury to acquit a defendant if they believe the law to be immoral. So basically, you know all those, you know how marijuana has been decriminalized in New York, but they still arrest people for it. Yeah. So, you know, that's a perfect example of, you know, when jury nullification comes into play. When a defendant faces marijuana charges, they should just be acquitted. Hey guys, I'm at the Bronx Hall of Injustice.
Okay, I'm going to pause through here. Alright, so jury notification is not nothing new, y'all. Okay? It set slaves free due to it. Due to jury notification, we could drink alcohol now. Well, it was one of the reasons why we could drink alcohol now. Prohibition had to go away. And I challenged, you know, people that like smoking marijuana, right? Well, I mean, if you go on a jury, you can basically say, you know, hey, even though it's a law, I still believe it's unconstitutional, and the government has no business telling me whether I can and cannot enjoy marijuana. Because remember, George Washington's job was farming hemp for rope. Alright, here we go.
Can I interest you in a flyer about your rights? Good, how are you? Just handing it out to anyone who will take it. So I have my jury info sign out. Been handing out flyers.
I've been 200 feet away from the courthouse.
Says who?
Says the law. And if you don't do it
Which
now,
law?
if you don't do it now, I'm going to put handcuffs on you. You're going to be placed under arrest.
Which law?
Do you understand?
Which law?
I don't have to tell you or point to a section. I'm telling you, it's in the criminal procedure law. It's in the penal law, actually. You have
Penal law?
Okay, I'm going to give you.
What would I have been arrested?
Listen to me. I'm about to place you under arrest. Is that what you want?
For free speech?
No, for violation in the law. The law says you can do this, but you have to be 200 feet away. Is that
For
something
free speech on a public space?
No. The law says you can do that 200 feet away from a courthouse.
Okay, well, you guys said you'd produce that, so I'm
No,
not
we don't
leaving
have to
unless you
produce
produce
Okay,
it.
put your hands behind your back. I'm going to place you under arrest.
Hello, everyone. This is Judge Park. I'm here along with Judges Newman and Lynch. We're ready to get started. We'll hear argument first in number 20-3161, Picard versus Magliano.
Good morning, and may it please the court, Eric Del Pozo for New York State. I've reserved 2 minutes for rebuttal. The district court's facial injunction on penal law section 21550 sub 7, which I'll just call the act, cannot stand. This court should do one of three things. One, order the case dismissed for lack of Article 3 standing. Two, direct that the act be enjoined solely to Mr. Picard's, as applied to Mr. Picard's jury nullification advocacy. Or three, certify the question of the statute's proper scope to the New York Court of Appeals. I'll start with standing. The district court correctly construed the act not to apply to Mr. Picard's advocacy, but erred in holding that it arguably did. Application of this statute to Mr. Picard's sign and flyer mode of expression was a category error. The act.
So you agree that the statute does not apply to Mr. Picard?
The parties dispute whether the statute arguably applies to Mr. Picard. Our
Yes,
position is
but that's not what I asked. I asked, you agree that in fact it does not apply from
that is our position, yeah. Yes, it plainly does not.
And but your position does not bind police departments or district attorneys around the state, does it?
That's right, Judge Lynch. This statute is fairly unique, though, in applying to the perimeter of state courthouses, where state court officers are going to be the primary enforcers, and no state court officer should or will be arresting Mr. Picard in the future, to the extent this court is concerned that a local prosecutor or police officer may, in our view, misapply the act to Mr. Picard or somebody engaging in similar advocacy. It could do one of the other two things that we've argued for in our brief: narrow the injunction solely as applied, which would provide to Mr. Picard's advocacy, which would provide him complete relief and cure those sorts of concerns, or certify the case for a definitive instruction. And then
DA's affidavit said that the reason for not prosecuting was that the distance was indeterminate, right? And so that seems to actually suggest that it wasn't because the law didn't apply to what he was doing, the actual activity. It was sort of where he was at in relation to the courthouse.
That's right, Judge Park, but that statement doesn't assume that the act applies. It simply takes no position on the question. It takes the path of least resistance. More important, we think, is that there's no definitive or even informal finding of probable cause, like there was in Susan B. Anthony list, which would support the view that the law objectively applies to Mr. Picard. Not simply that he credibly fears enforcement because he was unfortunately mistakenly arrested, but that there is objective statutory reading that could lead to a successful prosecution.
And just one other question about the state's position. One thing that I thought was conspicuous by its absence from your brief is any argument at all that if the statute did apply to Mr. Picard, it would be constitutional as so applied.
Yes, we are not taking that position, but to be clear, we are not rolling over. We seek to defend the statute and what we believe are its legitimate.
You're defending, yes, but you're not defending the constitutionality of the application of the statute to Mr. Picard.
That's right, not to the type of advocacy that doesn't concern any specific trial, and that's in accord with decisions like Pipeline, which construed the federal jury tampering statute solely to apply to specific trials as a matter of constitutional avoidance. So yes, the parties actually agree that were Mr. Picard's advocacy to fall under the statute, it would be protected. But this one mistaken arrest shouldn't be a pathway for facial invalidation.
And you also agree that the standard for standing is whether the law arguably applies. You just disagree with whether this statute even arguably applies to Mr. Picard.
That's right, Judge Lynch. And even if you consider the content of Mr. Picard's flyers, and our first argument is that he held a sign that has nothing to do with any specific trial. It's just an importunment for prospective jurors to come get leaflets, which are permitted under the Act. They're akin to one-on-one conversation, and as the cases have held, have constitutional protection. So the New York law wasn't targeting those. But even if you would consider the content of the flyers, they do no more than suggest that some unidentified subset of people should disobey some unidentified class of laws and urge research on jury nullification.
What if the flyer said, you must acquit in the case of State versus Smith?
If State versus Smith were pending in that very courthouse, that would be the paradigmatic application of what the law would bar.
Well, I thought one of your arguments was that the sign that he was holding didn't have to do with the case.
Oh, I'm sorry. If solely the flyer said that, then no, those wouldn't be covered. I'm sorry, I misunderstood the question.
He holds up a sign, says jury info, and then when they show up, he gives them a flyer that talks about the case.
This statute would not prohibit that, but if he knew that that person was a juror in State v. Smith, there would arguably be liability for jury tampering.
Would that be arguably covered by the statute then? I guess I'm trying to find out the line. What does arguable mean here?
Arguable
Why
means
is it not? Why is this not arguably prescribed by the statute?
for the two main reasons that we've cited in our brief. One, and this goes back to your most recent question, the statute precludes only shall any signage calling aloud things that could project to the courthouse entrance within the buffer zone, and a sign that doesn't concern a specific pending trial, or as here, really any trial wouldn't fall under the Act, regardless of what the flyers happen to say. But if the flyers, you were to consider the content of the flyers, in this case, those flyers wouldn't even arguably fall under the Act. The Act essentially takes the prohibitions on certain conduct inside the courthouse, like disrupting the trial or refusing to be sworn or answer a question, and exports them to the perimeter of the courthouse. But if this court did think that the statute arguably applied to misconduct, such that Mr. Picard had standing, we have two other arguments in the brief. It doesn't mean that Mr. Picard wins.
Does this record indicate whether a trial was going on at the time?
It does not, Judge Newman.
Does that matter?
It would for a prosecution under a proper reading of the statute. One of the ingredients would be, one of the elements would be proof of the particular trial that was pending, so that the advocacy outside of the courthouse would actually connect to something. We think that that's even more proof why this particular general jury nullification advocacy just doesn't fall under the statute.
Again, you take that position, and I realize the cases I'm about to mention are under different statutes, but the U.S. Attorney's Office took the position that a rather similar statute that I would think would be susceptible to exactly the argument that you're making, they actually prosecuted someone. Unsuccessfully, but they prosecuted. The government took that position. There's a Colorado Supreme Court case. Again, ultimately unsuccessful, but the fellow got prosecuted and the case went all the way up to the Colorado Supreme Court before he was definitively exonerated. So I'm just having, arguable is somewhat in the eyes of the beholder, isn't it?
So those two statutes.
I mean, you're taking the position that it would be frivolous for a prosecutor to take the position that this statute applied.
We are taking the position that a prosecution would not stand an objective chance of success given the proper scope of the statute. But again, given these concerns and the fact that the state does not control local prosecutors and local police, we ask that the court in the alternative affirm the injunction solely as applied to Mr. Picard. The statute serves two compelling interests, sort of flip sides of the same state interest. One, preventing actual disruption in trials, and two, the one that we think the district court didn't give enough heed to, that is promoting public confidence in the integrity of the trial system. I see that my time is up. If I could, I'd like to...
Could you just repeat exactly what you acknowledged to Judge Lynch about when it would be unconstitutional?
If the statute were applied...
Okay, I think we're going to pause it right there. That's going to be 15 minutes on my recording. All right, according to their 12 minutes on their recording. So this is 40 minutes long, so there's going to be a couple of videos. And the reason why I'm doing this, y'all, is to separate it where you can kind of review it by sections and not by the whole storyline. Junkyard News, if you just want to brush through there and look at his, by the way, subscribe to him. Alright, good job for him finding this and putting it up, because this is one of the things I talk about, especially during notification, but all the cop watchers and all that's First Amendment, so you get 2 in 1 on this one, even though it's technically First Amendment deal. Alright, this is We the People News. Bye, y'all.